Good afternoon, everyone. My name is Dan Brinks. I'm the co-director of the Rapoport Center for Human Rights and Justice, along with Karen Engel, who is the other director and who happens to be on leave this year. So she will not be around for most of the talks, although she's coming in from time to time. I'd like to welcome you to the first of our annual speaker series. The series is on natural resource governance, inequality, and human rights. The full schedule is on these little flyers, which you'll find around the room, and also on our website. We're really excited about the series this semester. I think for those of us who work in human rights, the question of natural resource extraction and extractivism has been one that's gained increasingly in importance over the last, decade or more. Wherever you go, I work mostly on Latin America. Wherever you go in Latin America, natural resources and natural resource extraction are at the center of a lot of the social conflict and a lot of the human rights violations that you find. And we have a series of speakers who focus on different aspects of this general challenge. We're starting today with Dr. Sumudu Atapattu, who I'll introduce in a moment. But we have other people coming, including people who work on sort of the more economic law side of international regulation of extractives. We have a really interesting speaker coming in October, Patricia Tobón Yagari, who's an indigenous lawyer from Colombia, who's also been involved in negotiating the peace treaty between the FARC and the Colombian government, and has been dealing with sort of the indigenous rights issues of that peace treaty. We have our very own Willie Forbath and Lucy White, a law professor from Harvard, who are working on an incredibly interesting project to look at sort of the regulatory framework for oil extraction in Ghana. And then we'll close it with a talk by Penelope Simons, who will talk about corporate responsibility for human rights violations around natural resource extraction. We think it's going to be a great semester. And as I said, we're starting with a talk by Dr. Sumudu Atapattu. She's the Director of Research Centers and a senior lecturer at the University of Wisconsin Law School. She teaches in the areas of international environmental law, climate change, and human rights. She has an LLM in public international law and a PhD in international environmental law from the University of Cambridge in the UK. She's an attorney at law of the Supreme Court of Sri Lanka. She's published extensively. Most recently, she has a book called Human Rights Approaches to Climate Change, Challenges and Opportunities, which came out in 2015, and also in 2015 with Cambridge University Press, a co-edited volume on international environmental law and the global south. She's published other books, but she has an activist side as well. She coordinates the human rights program at UW, University of Wisconsin-Madison, and has worked in Sri Lanka as a senior research consultant to the Law and Trust Society, and as the editor of Sri Lanka State of Human Rights 2002, which is an annual publication on human rights situation in Sri Lanka. She's currently the lead counsel for human rights at the Center of International Sustainable Development Law based in Montreal, Canada, and she's coming to talk to us about human rights law and what it has to say about inequality and natural resource extraction. So thank you, Sumudu, for coming. Welcome.
Thank you very much, Dan, for inviting me here and for that great introduction. Thank you also to Sarah and others and Julia. It's good to be here. This is my first time in Texas, actually. And I think I brought the rain here, so. And thank you all for coming here today. So just a little caveat before I start. I don't work on extractive industries, but many of the issues that I have been working on are very similar to the violations that we see in relation to extractive industries. So I'll be talking mainly about the link between human rights and environmental issues and how the human rights framework can be used in relation to environmental issues. And also because of the disproportionate impact on certain communities, the environmental justice framework as well. So this is an outline of my talk today. I'll be looking at 3 case studies. Actually, some of them have involved litigation as well. Shale Oil in Nigeria, Chevron in Ecuador, and La Oroya mining in Peru. I will look at the emergence of environmental rights and the right to a healthy environment at the international level. Obviously, I won't be able to go into detail. This is a huge area, and it has evolved into a huge area. But I'll be happy to answer any questions in the Q&A. I will also look at environmental justice as a framework and look at the intersectionality. If I have time, I will also look at this new framework. I shouldn't say it's new, but the framework relating to rights of indigenous people. Some of the principles are new, and I will conclude with some thoughts. Okay. So as you know, many of these activities are carried out by private entities, specifically multinational companies that are incorporated in northern countries but operate through subsidiaries or other legal forms in southern countries, right? So there have been many attempts at the international level to regulate the activities of these companies, but many of these attempts have failed. And technically, international law does not govern the activities of these companies because they are not states, right? So they generally operate in this gray area between national law and international law. So for most part, they have escaped regulation. But at the same time, we know that they wield a lot of influence and power and have enormous wealth. And in many instances, they are much more powerful than the countries they invest in. So this power asymmetry has resulted in a lot of injustices as well. So what we have in relation to these entities is soft law, right? Mainly soft law instruments and voluntary codes of conduct by these companies themselves. So things like corporate social responsibility, Equator principles in relation to sustainable developments, and more recently we have the UN guiding principles on business and human rights as well, right? And in addition to that, there's the Extractive Industries Transparency Initiative and principles for responsible investment and things like that. But as I said, these are all voluntary. So looking at the 3 case studies, this is Shale Oil in Nigeria, right? Quite a lot of environmental problems. Some more pictures. And as I said, this was a subject of litigation. So 2 NGOs brought action against the government of Nigeria in the African Commission of Human Rights. This is one of the 3 regional human rights bodies we have, and the only human rights instrument that incorporates a justiciable right to a healthy environment. The San Salvador Protocol to the American Convention of Human Rights also has a right to a healthy environment, but it's not justiciable, right? So in this case, the complainant alleged that the oil consortium has exploited the oil resources in Ogoniland, and this is predominantly an indigenous area, with no regard for the health and environmental consequences of the local communities, dispose toxic waste into the environment and local waterways in violation of existing standards, and did not address any spills. And the water, soil, and air contamination has led to serious health consequences on the people, as well as skin infections and things like that. So lots of health problems created by this environmental issue, and also which has an impact on the rights of people, right? And that's why they went to a human rights court. So the African Commission held in this case that states have a duty to protect its citizens under human rights law, not only through appropriate legislation, but also ensuring that they are not, their rights are not damaged by activities of private individuals, right? So that's an important principle, because when we talk about human rights, we think about obligations of states to protect its citizens. We don't really talk about the obligations of private parties or the obligations of states to protect protect its citizens from violations perpetrated by private parties. The Commission further held that contrary to its charter obligations and despite internationally established principles, the Nigerian government has given the green light to private actors, the oil companies in particular, that affected the well-being of the people, right? And said by any measure of standards, right? Its practice falls short of the minimum conduct expected of governments, right? And therefore, in violation of Article 21 of the African Charter, and Article 21 specifically relates to the subject that you guys are interested in, that it says all people shall freely dispose of their wealth and natural resources, and it shall be exercised in the exclusive interest of the people, right? And it further says, in no case shall a people be deprived of it. So the court held, in addition to several other rights, including a right to a healthy environment and right to health and things like that, the Commission held that there was also a violation of Article 21, right? So that was the Ogoni case, and I will come back to that in the context of right to a healthy environment. This is Chevron in Ecuador, right? Pretty bad stuff. More pictures, right? And you can see people bathing and washing clothes in this contaminated water. And again, we see indigenous people being affected as well. And Chevron case is interesting. It has been pending for more than 3 decades. But environmental damage spans over 50 years. And I think it's a textbook account of what should not be done on every account, right? So the story is very familiar. It was actually Texaco that originally went into Ecuador, and then it was bought by Chevron later on. Oil explorations began in 1964. And many of these people, who were, some of them were indigenous, had no idea that Texaco was operating in the country until they heard helicopters coming in. I don't know whether you have seen the documentary Crude. It was based on this issue. There were oil spills, many waterways were polluted, many people got sick with cancer, some kids even died as a result. So if you get a chance, I highly encourage you to watch that documentary, because it captures basically everything we are talking about today: corporate social responsibility, multinational companies, the link between human rights and the environment, etc. But Chevron, it's also interesting to see the tactics that were employed by both Chevron as well as the plaintiffs. Chevron fought really, really hard to bankrupt the plaintiffs' attorneys in this case. some of the cases are still pending, actually. Chevron filed action against the Ecuadorian government for violating an investment treaty, and I think there was a judgment against Ecuador. So again, this highlighted the power asymmetry between one of the largest companies in the world and a developing country and a poor community. And to date, these people haven't received any compensation, any relief really to the problem that's still continuing. And La Oroya in Peru, saw some of the pictures from there. There are several mining operations going on, lead, zinc, and copper, I believe. And this is considered as the most polluted place on Earth. At least it comes within the top 10 most polluted places, right? Here, about 35,000 people are affected as a result of this. It's the severe environmental contamination, and there was several violations. The company was cited many times and closed the smelter in 2011. Again, we have a multinational company which is incorporated here in the US, operating in a developing country, and again, the company filed action against against Peru for violating the free trade agreement between the two countries, right? So this seems a pretty common practice where the company is going against the state for violating a free trade agreement, right? Again, there are lots of health problems. Children have tested positive for really high levels of lead, way more than the standards imposed by the US Center for Disease Control. So again, as far as I know, there hasn't been any cleanup operations, right? So all three case studies, if you look at them, involved severe environmental degradation, right, with long-term impacts on health impacts on the people, leading to serious human rights violations. Right to health is a right recognized under international human rights law. Invariably, there's a multinational company based in a northern state operating in a southern state. These are all extractive industries. Of course, it's not confined to extractive industries. In addition, of course, we have indigenous companies. And in the Ogoni case, there was clear evidence that government forces were actually involved in creating these violations against the people as well. So there was collusion by government forces. So, having given that sort of background, let's talk about the link between human rights and environment, right? Because you saw that these environmental problems have a serious impact on the lives of people, on the health of people, right? So what is the link between the two, right? We have environmental law on the one hand, we have human rights law on the other. How do these two converge, right? So it's obvious that environmental degradation has a direct impact on people and their rights, right? But the environmental law framework at the international level lacks the sophisticated redress mechanisms that international human rights law has, right? International human rights law, I don't know to what extent you're familiar with these mechanisms, but international, it's both treaty-based and charter-based, and these treaty mechanisms have complaint mechanisms for people, and then at the regional level there are 3 human rights commissions and courts that can hear petitions from victims, right? the environmental framework does not have that redress mechanism. So what people started doing, the victims started using the human rights framework to seek redress for their environmental problems, as long as they were able to connect the two, right? So this started in the 80s, actually consolidated in the 90s, and now we have a robust body of jurisprudence, mainly from these regional human rights courts, that have articulated environmental rights, right? And some have, like the African Charter that I mentioned, actually recognizes the right to a healthy environment, right? So this was one of the earliest cases before the European Court of Human Rights, Lopez Ostra versus Spain. The European Convention on Human Rights does not recognize a specific right to a healthy environment. So this case was filed under Article 8, which deals with right to privacy and family life. So Mrs. Ostra and her family lived in a town in Spain that had a heavy concentration of tanneries. The children started getting sick, and the pediatrician recommended that they move to a different area because there was heavy air pollution coming from these tanneries. And the symptoms were consistent with living in a highly polluted area, right? So the court found a violation of Article 8. You might ask why it was not filed on the basis of right to health. Again, the European Convention, remember this was 1950, one of the earliest regional treaties we have. So there's no separate right to health recognized under this. So many of the environmental cases have been filed under Article 8 in the European system, and other regional courts have dealt with this issue as well. As well as at the international level, the ICJ has also dealt with this issue, although they haven't really gone into details. At the international level, of course, the petitioners or the actors are states. But in the Hungary versus Slovakia case, in the separate opinion, Judge Viramantri linked environmental protection with human rights and said it is scarcely necessary to elaborate on this, as damage to the environment can impair and undermine all human rights, spoken in the Universal Declaration. So it drew a clear link between environmental protection and human rights. So it's interesting to see how this convergence took place at the international level, and I think two developments at the national level actually contributed to this development at the international level. So one of them is the environmental impact assessment process that's subject to public scrutiny in many countries. It's a public document, and public can participate in the decision-making process. So you can see the environmental protection laws incorporating some of the rights in the human rights field, right? Access to information, participation in the decision-making process are part of human rights law. And this has actually been incorporated now in an international treaty called the Aarhus Convention. It has a really, really long name. But basically, it recognizes that these procedural rights are in fact being recognized in order to feed into a substantive right to a healthy environment. So if you look at Article 1, it says in order to contribute to the protection of every person of present and future generations, it encompasses future generations within this formulation, to live in an environment adequate to his or her health and well-being, right? The Aarhus Convention is a regional treaty. It's confined to the ECE, European Commission for Europe, but other states can accede to this convention, right? So this was the first time that these rights were actually incorporated into a into an environmental treaty. So you can see this convergence taking place in treaties as well, right? The other development is, the other national development is the environmental justice movement in the US. You know that there was actually an presidential executive order on environmental justice issued by President Clinton in 1994, requiring each federal agency to make achieving environmental justice part of its mission. Right, and interestingly, there's a case pending before the Inter-American Commission of Human Rights, brought by Mossville Environmental Action Now versus U.S., saying that alleging environmental racism and justice. So it'll be interesting to see how that's resolved. Right. So this recognizes that certain practices in the US where these polluting activities were mainly located in low-income and racial minority communities, so they were disproportionately affected by these polluting activities. So again, you can see these two movements merging. So, what about a right to a healthy environment, right? I said that these two areas have been merging, but do we have a right to a healthy environment at the international level? Right, so international law, international human rights law does not recognize a specific right to a healthy environment. None of the human rights treaties at the international level recognizes this right. Right? But there's an increasing move towards articulating environmental rights at the international level through the case laws that I mentioned earlier, right? So what are the pros and cons of adopting a right to a healthy environment, right? And what are the pros and cons of using a human rights framework in relation to environmental issues, right? Because these two areas are not necessarily the same. They don't necessarily match well together, right? Because in the environment field, we are not just talking about human beings, whereas the human rights framework is obviously confined to humans, right? Although there may be some movement about that too. I mean, it's changing a little bit as well, right? But predominantly, when we talk about using a human rights framework in relation to environmental issues, we are talking about the impact on people, rights of people, right? So many environmentalists argue that by doing that, we are excluding 6 million or 5 million other species that are there, because we are again putting emphasis on people, right? Many of these environmental problems create problems for future generations. Climate change is a good example where many of the problems will be felt by the next generation or the generations to come. But the human rights framework cannot capture that, because you need to have a victim right now, right? So how do you articulate future generations within the existing human rights framework, right? Extraterritoriality is another problem, right? Again, some of these environmental issues have transboundary impacts, right? Human rights law operates vertically between your state as a duty bearer and you as the rights holder, right? So let's assume that along the border here, if Mexicans are affected by something that's going on in the US or vice versa, right? You cannot use the human rights framework to file action against another state, right? Not technically. In the Inuit case, they tried to do that, and there is some jurisprudence on diagonal claims, but basically human rights law operates vertically, right? So you cannot bring an extraterritorial claim either, right? So that's another limitation, and many of the environmental issues have transboundary impacts or global impacts, right? So there are limitations, but to the extent that there are actual victims and they can use the human rights framework, it has been a useful tool in the hands of these victims, right? And then you can see from some of you read the petition that that was submitted to the Commission on Human Rights in the Philippines with regard to climate change. Their human rights framework was used in relation to climate change to go against some, they're called carbon majors, the major companies that are responsible for climate change. So the question is, should international law also recognizes a distinct right to a healthy environment, and if so, what are the parameters of this right, right? So even in the absence of such a right, and politically I don't think this is ever going to happen. I mean, I hope I'm wrong, but I don't think there's any political support for the recognition of a distinct right to a healthy environment. But even in the absence of that, it's noteworthy that there's a definite trend towards articulating environmental rights, at least by these regional human rights courts. And secondly, many national courts have also interpreted constitutional rights to include a right to a healthy environment. So for example, the Supreme Court of India, for example, has articulated or interpreted right to life as encompassing a right to a healthy environment. And moreover, many new constitutions incorporate some kind of an environmental right. Right? So David Boyd has done a book looking at the constitutions in the world, and he says that there are over 100 constitutions that incorporate this right in some form or other, right? So there's a definite trend both at the regional level, at the national level, to articulate a right to a healthy environment, right? So what does this trend mean? And in addition, at the international level, we now have, and actually he's now the special rapporteur on human rights and the environment. Earlier he was appointed as an independent expert by the Human Rights Council, right? So again, recognizing that there's definitely a link, and this area should be further developed, right? And in his mapping report, he recognized that international human rights law imposes both substantive and procedural obligations on states with regard to the environment, right? And he said these are the substantive obligations. States have a duty to adopt and implement legal frameworks relating to environmental harm that have an impact on the enjoyment of rights, right? In addition, states have a duty to ensure that activities by private actors do not cause harm either, right? And when these laws are implemented, you have to do that in a non-discriminatory manner, right? And in addition, the procedural obligations that we talked about earlier, which are clearly part of international human rights law, are established. In addition, he identifies assessment of environmental impact, assessing environmental impacts on human rights is another procedural right that's more or less established, right? And in addition to these substantive obligations and procedural obligations, he says that there are certain communities that are more vulnerable than others, and there are obligations under human rights law to protect these groups. There are additional obligations relating to these groups, and these are women, children, and indigenous groups. And with regard to other groups, more work needs to be done, right? So his conclusion is that human rights law already has clear enough obligations to provide guidance to states with regard to the environment, right? states and other actors should take these human rights obligations into account when developing and implementing their environmental policies, right? So we already have an established body of laws under human rights law that are applicable to environmental issues, and states must abide by those obligations when taking action in relation to the environment. And the other issue is one of the critics of recognizing a right to a healthy environment is that, oh, we cannot define that right, right? What are the parameters of this right? But in the Ogoni case, the African Commission on Human Rights clearly established what the rights, what the obligations of states are in relation to this right, right? And said that the right to a general satisfactory environment as guaranteed under Article 24 of the Charter imposes clear obligations upon the government, right? And went on to say what these obligations are. Said states must take reasonable and other measures to prevent pollution and ecological degradation, to promote conservation, and to ensure sustainable development of natural resources, right? In addition, there has to be independent scientific monitoring. You have to require the assessment of environmental and social impacts, undertake monitoring, right? Providing information to the communities and providing meaningful opportunities for these communities to participate in decisions that affect these communities. Right? So a bundle of obligations were recognized by the court as emanating from a right to a healthy environment. And these are obligations that we already know of, right? There's nothing new here, right? Environmental impact assessments are part of many national laws, right? Public participation, undertaking monitoring, these are already part of laws, national laws that many states have. Right? So far from being sort of vague, this obligation actually imposes additional obligations on states to take certain action. Almost 10 minutes. Okay. Maybe I will. I'll probably skip a few of these. But this was an interesting case. I mentioned the extraterritoriality of, or the non-extraterritoriality of the application of human rights law. This case was brought by Ecuador against Colombia before the ICJ. It was later settled by the parties, so there's no judgment. But this was an interesting case where Colombia was spraying herbicides along the Colombian-Ecuador border, and Ecuador argued that there was extensive damage along the border to the people living along the border and a violation of human rights in the Ecuadorian territory, right? Including violation of rights of indigenous people living along the border. So if there was a judgment, that would have shed light on the extraterritorial application of human rights. So the argument here was that Colombia was responsible for the human rights violations that were taking place as a result of its activities on the other side of the border in Ecuador, right? So we can discuss whether this is a good thing or not, and then where they're going to file action. I mean, can Ecuadorians actually file action against Colombia maybe in the Inter-American Commission, right? So to look at the justice framework now, I looked at the link between human rights and the environment and using the human rights framework. Now I'm turning to the environmental justice framework because we saw that many of the activities are undertaken by very powerful companies, but the impact is disproportionately felt by marginalized communities in these developing countries, right? So what does this mean? Here I use the fourfold sort of framework proposed by Robert Kuhn. I believe, I don't know how to pronounce his name, unfortunately. And he proposes a framework of distributive justice, procedural justice, corrective justice, and social justice. And of course, there are problems with this, at least in the implementation, you run into issues. But the basic idea here is that when you talk about distributive justice, and this is related to equal treatment, there has to be equal distribution of goods and opportunities for everybody, right? But this also recognizes that in certain instances, because of historic marginalization, certain groups might have to be treated differently and given a leg up through affirmative action and things like that in order to achieve distributive justice, right? Procedural justice, we talked a lot about the procedural aspects, so I'm going to skip this, and this overlaps with international human rights law. Corrective justice goes to correcting injustices inflicted on communities and punishing those who are responsible. And as we know, in relation to the examples we discussed, this aspect is lacking in many countries, right? The victims do not receive any compensation. It's very hard for these developing countries to control the activities of the private companies because, you know, they wield so much power. We saw when states tried to do that, they were sued under free trade agreements, so this power imbalance has been quite problematic, right? And in addition to that, the host state might have lax environmental controls. I mentioned the investment treaties, and there are special project finance structures that actually shield the company, so sometimes it's hard to find out who is actually responsible. And we come to the last component, which is social justice, which is also probably the most problematic, because here the argument here is that you have to look at the existing injustices that have contributed to these environmental problems. So here the argument here is that social, racial, and economic justice are all part of one, so you have to look at those underlying causes of injustice if you are serious about addressing these justice issues, right? Intersectionality, these frameworks as well as these injustices compound each other, so often these intersectionalities are not looked at. That's another problem, right? Skip some of this because I think I have.
We can always pick these up in the.
Yeah. So one thing I should quickly mention is this the Ragi principles. There is UN guiding principles on business and human rights. Again, a soft law initiative, but they try to bring these companies within the human rights framework, at least to the extent of protecting the people. So I think I will stop there. I have many more slides, but I will stop there.
Great. So let me then introduce our respondent and say a word about the process for the rest of the conversation. So the speaker series is part of a seminar, and many of the people who are here are students in the seminar. We usually give them a first shot at asking questions of the speaker or the respondent, and then we'll open it up to the rest of the group. We're lucky enough to have Jason Cons as our respondent today. He's an assistant professor in Anthropology. If you want to come on up, he's the author of a very recent book. A few months book called Sensitive Space, Fragmented Territory at the India-Bangladesh Border. He's been writing on on climate change and on issues that arise on the border between India and Bangladesh relating to environment and climate change in particular. So thank you, Jason, for agreeing to come.
So thank you. I'm going to try and be brief, and maybe I'll be a little schematic with what I've prepared here so we can open up the conversation. But I wanted to start by thanking Dr. Atapattu for her thoughtful and very thought-provoking paper, and also thank the Rapoport Center for inviting me to respond to it. The argument that you've articulated today and its normative intent, the establishment of durable international frameworks that enshrine environmental rights as human rights in law, is one that I completely agree with in both principle and practice. And so therefore, most of what I have to say today is more by means of provocations about things that would be useful to think about alongside of this crucial task. These are framed both by my profession and training as an ethnographer and as an anthropologist, and also by a decade-long engagement with Bangladesh's landless movement and their struggles to actualize environmental and other forms of rights that are often already enshrined in both international and national law. And it's this question of what exists now and what's already existing that I'd like to focus my attention on today. I'm going to raise 4 brief provocations, all of which are meant not as critiques of the argument of the talk per se, but rather as concerns about the limits of international legal action and intervention in an era not only of intensified resource extraction and frontierization, but also, of course, of climate change. So my first question concerns the challenges of thinking about the question of instilling international rights to healthy environments through the lens of cases around extraordinary petroviolence and corporate exploitation. I recognize that this isn't necessarily the thrust of your overall work and that it's something that you're addressing specifically for this talk. My question here is not whether we should think critically about Shell, Chevron, Union Carbide, and other corporate polluters. Of course, certainly we must. But rather whether they provide a solid and useful starting point for thinking through the complexities of the relationship between law and environmental justice in an international arena. As you point out, the story of these cases is a familiar one of corporations' corporate exploitation, expropriation, and lawlessness. They're cases of, in many ways, unambiguous environmental violence directed often at indigenous communities. The misdeeds of petroleum companies, I think, make them, in many cases, somewhat easy to represent as the villains in stories of environmental degradation, personifications of rapacious capital, intent on devastating the earth through often military-backed extractive technologies, targeting more or less powerless groups. Now, true as this vision certainly is, I think it also risks simplifying our notion of causality and narrowing our understanding of the process of resource exploitation. This in turn presents the works of environmental justice, human rights, and law as curbing and disciplining unruly and exploitative corporations who exploit chains of powerlessness to achieve their ends. So my concern with this is twofold. First, as I mentioned, I think this somewhat oversimplifies the story of how frontierization and extraction is happening in the contemporary moment, and the complicit chains and relationships through which such companies attain the right to extract resources from often indigenous lands. As works such as Steve Cole's magnificent book, Private Empire, have shown, the extractive relationships, these extractive relationships are often predicated not simply on greedy corporate interests, but they're deep-seated relationships both with states and international development agencies, like, for example, the World Bank, and your presentation points this out as well. These groups are often as complicit and significantly harder in many cases to hold accountable than their corporate partners, at least in the court of public opinion, if nothing else. While international law could conceivably posit frameworks to challenge corporate interest, the broader question of the domestic and international systems that facilitate such exploitation remains, I think, a much more difficult task to tackle through frameworks of international law, as many cases around the world are contemporary showing. My second concern here is that framing the debate over environmental human rights around such clear-cut cases of exploitation risks failing to engage with more marked forms of what Rob Nixon has called slow violence around questions of development and conservation, and certainly issues of climate change that continue to undermine not only the rights but livelihoods and socialities of communities that are the supposed targets and beneficiaries often of development interventions. For example, the epidemic of arsenic poisoning in tube wells in Bangladesh is a source of slow and insidious erosion of both health and well-being for communities throughout the country. It's also the result of a long chain of events and processes, from Cyclone Bola in 1970 to the Liberation War in 1971, following hot on its heels, to the opening of the country to the development industry in the period in the famine following the Liberation War, to the broad adaptation of green revolution technologies throughout the country, which placed tremendous strains on groundwater resources, to the substitution of groundwater by the proliferation of development-supported tube well adaptation, et cetera. Culpability for crises such as these, I think, is significantly more difficult to establish and more challenging to establish. And I wonder if starting with these more complicated cases might lead to a more durable framework for preserving rights and justice at an international scale in ways that, starting with corporate misdeeds, perhaps won't. A second concern I want to raise is is highlighted in your discussion of procedural justice, which I know you moved through fairly quickly. You rightly celebrate the important strides of the environmental movement in normalizing procedures that are designed to protect vulnerable populations on whose land extraction takes place and who are both the subject and object of development interventions today. Things like environmental impact assessments, stakeholder engagements, and new policies of free, prior, and informed consent, or FPIC. I agree that these are absolutely indispensable tools in the hands of states, activists, and communities for holding corporations and development organizations accountable for the projects that they implement. Yet there are also technologies of accountability that have really marked limits. This is in part because they tend to place the power of producing what Michael Goldman has called authoritative green knowledge in the hands of organizations that are already expert in managing such processes along narrow and fairly well-defined and often teleological lines, where the ends always seem to somehow justify the means. While environmental assessment studies are crucial, they're also easily worked around and trampled on, as activists protesting a range of dams, power plants, and other projects around the world will readily tell you. In my own experience, the concept of stakeholder engagement is a fairly hollow one, a step undertaken now by every new development or commercial project in which the same narrow band of largely landed property owners and communities are gathered in rooms to articulate their own narrowly and self-interestedly conceived understanding of what a community wants. You ask any development professional in Bangladesh about stakeholder engagement, and they'll talk to you at length about the importance of getting the people what they want, but if you ask them which people, you tend to get confronted by puzzled silence. Moreover, I think as recent work on REDD+ programs in Southeast Asia has shown convincingly, FPIC processes are equally open to elite capture, particularly in the context where westernized legalistic notions of things like informed and consent brush against much more fluid notions of community and debate. In such context, it turns out that FPIC might be just as fungible as other well-integrated measures to mediate environmental impact and exploitation. So, of course, the challenges of accountability and monitoring don't mean that we shouldn't work to enact and think through frameworks of environmental justice, rights, and international law. That's not what I'm saying at all. And I'm in absolute agreement that such questions are not only crucial, but critically urgent. I also share your concern that such frameworks of legislation might have limited impacts in states where weak democratic structures and unequal access to mechanisms of justice obtain. Indeed, I often fear that Hannah Arendt's famous rumination that the loss of national rights in all instances entailing the loss of human rights and the restoration of human rights only being able to be achieved through national rights might continue to prove doubly prescient in the domain of environmental justice. My suggestion then would be that we look first not to legal frameworks, or at least not exclusively to legal frameworks, but also to civil society. Arguably, every act of environmental violence is linked to extraction or to development, might also be thought of as a breakdown in some form or another of civil society. The roots of such breakdowns are, of course, various, ranging from depoliticization to co-option to more overt forms of legal and police violence trained at activists and unruly communities by repressive states, often working at the behest of those with tremendous stake in ongoing resource exploitation. The question to my mind then becomes not only what kinds of frameworks could be put in place to enshrine environmental rights in international law, but also and simultaneously what kinds of strategies can a community of internationally concerned activists, scholars, politicians citizens, etc., do to help advance the kinds of democratic engagement that are often either the primary or secondary victims of environmental exploitation and corporate extraction. So I'm not naively suggesting here, I hope, that fostering democratic engagement is necessarily a more straightforward process than protecting environmental rights. Clearly it isn't, and it's extraordinarily complicated. However, I think that it's notable that in many cases of environmental and extractive violence around the world, again, as your talk points out, corporations and development agencies are often already in violation of laws and constitutionally guaranteed rights that might, were they to be enforced or actualized, serve to help protect indigenous and other communities and the resources upon which their property claims rest. To that end, I'd suggest that in parallel and linked to projects of establishing international legal frameworks to protect environmental rights, we should continue to explore the possibilities of what A.L. Weitzman has recently called forensis, or an architecture of public truth. Weitzman writes that, quote, forensis is Latin for pertaining to the forum and is the origin of the term forensics. The Roman forum within which forensics pertained was a multidimensional space of politics, law, and economy, but the word has since undergone a strong linguistic drift. The forum gradually came to refer exclusively to the court of law and forensics to the use of medicine and science within it. This telescoping of the term meant that a critical dimension of the practice of forensics was lost in the process of modernization, namely its potential as a political practice. A renewed attention to forensics implies an extended rumination on the technologies and processes through which truth is constituted, as well as a forwarding of a set of tools, legal, technological, and otherwise, whereby truth claims about things like public benefit and environmental well-being are, on the one hand, made and on the other, contested. What this implies, I think, are a strengthening and attention to the ways through which communities, activists, and civil society groups can access and counter epistemic claims about the land that they live on, the benefits of intervention, and the unequal trade-offs made in the name of development and environment in the contemporary moment. What these ways and means are is in need of serious ongoing debate and discussion. But some recent and suggestive progress has been made in the pushing of right to information legislation in places like Bangladesh and India. My sense is that RTI legislation, which aims at providing civil society access to the murky workings of power, legislation, and decision-making, is a potentially enormously proactive tool for helping communities under threat to actualize claims that are already enshrined in law. In Bangladesh, the landless groups that I work with responded to the passage of the RTI in 2009 by using it as a tool to counter and challenge many NGOs implementing conservation and development schemes in the places that they lived. In fact, they started filing these right and left as quickly as they possibly could. Now, such practices, of course, slowed the implementation of these projects, but they also provided a useful and indeed, in many ways, satisfying corrective to intervention in a country where development organizations have historically operated in extraordinarily high-handed ways that effaced landless groups from deliberative planning and occasionally implemented solutions that made life considerably worse for both marginal groups and the lands on which they lived. So in conclusion, my suggestion here, again, is not that we abandon the struggle to enshrine environmental rights in international law. Such a project remains crucial. Rather, I'm suggesting that such a discussion needs to be carried out in dialogue and in parallel with a project that rethinks and reinvigorates a robust civil society that has historically and globally been most effective at drawing attention to environmental injustice and holding states, corporations, and development organizations accountable for their actions and clarifying the interests in which they work. Thanks again for a very great paper.
All right, so thank you, Jason. We're recording, so if at all possible, if you have a question, we'd like you to pose it with a microphone, and we'll have somebody walking around handing you the microphone. So, as I said earlier, we have a first round of questions that we let the students have a first shot at, and then we'll open it up more generally. I know you've been patient with us, and so we're anxious to hear from the rest of you.
So Florian,
Yeah, so what we'll do is we'll take 2 or 3 questions maybe, and then have a round of answers. And so as you were about to do, introduce yourself and then.
my name is Florian Lehne. I'm from Austria and doing an LLM here. And obviously a member of the seminar, so I had already the possibility and opportunity to read your views on the link between human rights and environmental law. And as you pointed out, it's a difficult relationship. You hinted at that with your title, harmony or mismatch, as well. And you were also talking about business, international business law, arbitration, investment law, and so on, which is another level where sometimes these conflicts are brought to. But I would like to ask you, if we have these three scales, let's say international or regional human rights bodies, deciding on human rights violation which are related to environmental issues, then we have the international environmental law, which lacks any body of settlement. There might be some implication of human rights there. And the third question would be, how do you see that on an international investment law level? Is there any possibility to sneak in a human right to a healthy environment? Thank you.
Hello. My name is Daniel Jimenez. I am a master's student at the LBJ School, second year student in global policy, specializing in human rights. As you were talking about the emergence of a distinct substantive right to healthy environment, and talking about part of the problem of that emergence is almost a question of political will, if you will, some overt politicization. In your paper on small island developing states, you sort of talk about how for the first time we're going to have an unprecedented issue of territories actually being lost, and so the very idea of state sovereignty sort of being lost with that. And I was just wondering if you think that that would maybe eliminate some of the political issues, or maybe give more cause or impetus for the emergence of an actual substantive right.
Hi, Dr. Atapattu. I'm Ami Egerstrom. I'm a PhD candidate at the Government Department, and you touched upon this just very briefly with regards to the Ogonia, Nigeria, but I was wondering how the indigenous rights framework is, just about generally the intersectionality between the indigenous rights framework being used for environmental claims, and if this is even more limited by its exclusionary nature, applying just to indigenous people, or if this is kind of a bolster for this inequality that is obvious when you're dealing with indigenous people and powerful corporations or states.
Should we take those? I see there are a couple left yet, but why don't we take those and then...
Okay. Great, thank you so much.
Feel free also to pose questions for Jason. Some of these comments were quite provocative.
So that I'm not all alone. Yeah, I mean, I completely agree with the issues that you raised about civil society. I mean, many of these cases have been brought by civil society groups, not just the victims. So they have actually been at the forefront of this convergence. So, but of course, I'm a lawyer, so I believe in law and the power of law. And law is pretty powerful, right? Investment law, I don't know anything about investment law, but I know that it's pretty one-sided because of this power asymmetry. I mean, these are treaties that states enter into, but they give the right to these companies to sue a state. So you can see, I mean, the way they operate is pretty one-sided, right? So including human rights, I may be totally wrong, but NAFTA was, an investment treaty where they actually have an environmental chapter, but this is an area that I don't know much about, so I don't really want to go there. But the point that I was trying to highlight was that these companies engage in massive human rights violations, massive environmental degradation, and when people try to get some relief, like in the Chevron case, Chevron make use of these free trade agreements to go against the host state. So that was the point I was trying to make. In the meantime, of course, the people are without a remedy, right? With regard to small island states disappearing, I don't know whether it will be an impetus for the international community to recognize this right, but on a practical level, even if they recognize this right, I don't know what the usefulness of that would be if the international community is not serious about cutting down their emissions, because these islands are going to disappear anyway, right? So on a practical level, I don't know to what extent it will help these communities, because if the emissions are not going down, it's the death sentence for them, right? So I don't know whether it will be helpful at all. And also, even if they try and bring an action to enforce that right, because the way human rights are structured, the people will have to file action against their state, and their state is not really responsible for what's happening, right? So that's why the justice framework would be more useful. But again, you know, when you try to apply that in practice, you run into problems, right? How the indigenous rights framework can be used. I had a slide on the FPIC principle, and you alluded to that as well. So the free, prior, and informed consent principle has evolved, again through case law as well as through the UN Declaration on Rights of Indigenous People. These are some of the cases that have dealt with this issue. And the Declaration on Rights of Indigenous People, again, this is a soft law instrument, recognizes that at least in 4 instances, this principle applies. So this is an extension of the principle, the procedural principles that we talked about earlier, requiring consent, informed consent of these groups. So it's a specialized sort of a higher principle that the international community has come up with, particularly in instances where these groups are going to be evicted from their traditional lands. But as you pointed out, in practice, again, you know, it has been very difficult to apply this principle, because if there are several indigenous groups, who can give consent on behalf of the entire group? And there have been instances where they have been just told to sign a blank piece of paper by the investor. They have no idea what it was about, and when they try to identify the perpetrator, they are sort of shielded by these complex project finance structures. So in practice, you know, we have run into issues of actually implementing these principles. So I'm not saying the principles are bad, but in fact, this points to what you were talking about. In practice, it has not been easy to apply these principles. Okay.
We'll take a couple more and, from the students, and if anybody else wants to pitch in.
Well, my name is Karina. I'm also from the seminar, an LLM student. I have a question about new strategies that these kind of issues may raise in human rights advocacy, for instance. If you believe that maybe it's possible to address alternative strategies considering like IMF or World Bank, IBD, like new actors, not traditional human rights organisms or protection systems as individual complaints, I don't know, hearings, like what is the new scenario that these kind of issues actually raise in human rights advocacy? And the second question, it's between the difference, if there is any difference between decision-making process and prior consultation, because sometimes like the prior consultation are made once the decision is already made, so maybe this also raises a new question in what we actually conceptualize as decision-making process. And the third question, if that is not much, is concerning corporate responsibilities in companies or multinational actors. Because, for instance, in Argentina, up to now, corporate responsibility is still considered some kind of donations that companies can make to foundations, associations to avoid taxes. So it's like if we use that concept, we are not making any progress, and there's a lot of things to be done, for instance, in Argentina. So that would be the questions.
Okay. Well, I just have a question about, at the end of one of your papers, you were talking about the Paris Agreement and how we can consider a success that they have actually included human rights mentioned in the preamble. But also you mentioned that it was a missed opportunity to address one of the most important problems climate change will have in all of us, it is people's displacement. So I had a question if you have any standard of what they should call it, but not only about the name, but if it's better to use refugee, displaced person, migrant, and what kind of consequences will come from categorizing in each way.
Yeah, hi, my name is Scott Squires. I am a dual master's student in global policy and journalism, and my question is more for Dr. Kahns, but also for Dr. Atapattu, if you can chime in as well. Dr. Kahns, you question the efficacy of implementing certain legalistic mechanisms in countries where the judicial system is spotty, instead placing the onus on civil society organizations to fill that void. But my question is, what about in places where civil society organization is difficult or downright illegal, such places like China or something like that, where dissent is quashed or just sort of non-existent? Is there a point where a right to a healthy environment could fill that void?
That's a great question. People always end up asking me questions about China, and I know very little about it. I guess my general response is, again, not so much to suggest that we don't need rights-based frameworks or international law that backs them up, but rather to suggest that an important parallel process, and I think that this holds particularly in countries where dissent in civil society are extraordinarily challenged, where part of the job of the international community should equally be pressuring for mechanisms that encourage more deliberative democratic practice. And in my experience, in most cases, I find that giving the groups that actually bring attention to environmental violence, often civil society groups, more tools to work with, is as effective as establishing frameworks that often, if you're thinking about development organizations, typically development organizations look like they're already in compliance with these frameworks, when in reality and in practice they often aren't. So that's the impetus for the comment that I was making.
So looking at alternative actors, that was your question about the IMF or the World Bank. Under the human rights framework, you cannot, because I talked about the vertical relationship between states and victims. But there are other sort of fora, like the World Bank Inspection Panel, where victims can bring claims. But not under the human rights framework. there has been an issue with regard to, well, many issues actually, with regard to the clean development mechanism under the climate change legal regime, where they make sense from a climate change point of view, but have run into, these are projects that have been approved by the clean development, whatever, the executive body or whatever it's called, but they have run into, in implementing, run into lots of human rights violations, and the argument is that, it's not one of our mandates, right? Come on, I mean, these are international human rights law. You can't say that, it's not part of your mandate. So there has been a lot of civil society groups that have lobbied to include human rights requirements in the approval process. So there are different ways of bringing human rights into this, but if you want to go against these entities, it's hard to do that under human rights law. You cannot take the World Bank to a regional court or whatever. You cannot do that, but there may be other mechanisms that you can influence these processes. Responsibility of companies, that's what we are trying to do, because and some parent companies have been actually requiring these subsidiaries that operate in developing countries to be more environmentally friendly, to respect rights of individuals in the countries that they invest in. But again, you cannot hold them accountable under the human rights framework, right? The Ruggie principles try to say that there are basic standards that these companies have to abide by. They have to respect the laws of the host country. But, if the host country does not have adequate laws or have corrupt systems, as you pointed out, it's a little hard to rely on the host state to protect the rights of the individuals, and in some instances, like in the Ogoni case, the government forces were actually working with the company to violate the rights of people, right? So it's hard in situations like that when your own government is responsible for the violations of your rights. I didn't quite get your question about the decision-making process and prior consultations.
It's just that I think that maybe this kind of situation challenged what is understood by decision-making process. Sometimes it's like linked with prior consultation, and prior consultation also may, of course, when the decision is already made.
Right.
So we have to like reconceptualize maybe that.
Right. So again, this goes not so much to the law, but the way it's implemented. And again, that's a point you made with regard to environmental impact assessments and things like that. Often they are used to justify a decision that has already been made, right? So ideally, the environmental impact assessment is to see what alternatives, you have several alternatives, and the decision maker is given the pros and cons of each alternative so that they can make a decision. But what has happened in practice is that these documents are tailor-made to justify a decision that has already been made, right? So that doesn't mean that the tool is bad or the law is bad, it's the way it has been implemented in practice. So it's like throwing the baby with the bathwater. The tool is good, but the way it's being implemented is the problem, right? But you're right. I mean, sometimes these are just sort of window dressing to show that, we did this. But in reality, there were no proper consultations. And we talked about this when we met with in a smaller group earlier. Sometimes, depending on what the group is, there may be an additional obligation on governments to actually educate these communities, because some of them, how many of us can understand these environmental impact assessments, right? They are such technical documents. So even if it is a public document and people people can actually get a copy of it, nobody will be able to understand them. So there may be something, a step further for these officials to actually educate the public. And then the civil society groups have done a great job in, deciphering these documents for the public and using them. I mean, some of these have been challenged in courts too, to show that, they don't comply with the law, because one of the requirements is to look at alternatives, right? And there was a case in my country to say that at least a summary of these documents should be published in all national languages, because, if it is in English, how many of us, can understand, things like that. With regard to climate refugees, I agree this is going to be a huge problem. But again, when we talk about climate refugees, I mean, it's not a legal term. We currently don't have a legal framework to govern people who will be displaced as a result of climate change. But again, we need to look at those who will move across borders and look at those who are on small island states who will also be displaced, but they won't have the protection of the state anymore, right? If the state itself is disappearing, what are we going to do about these people, right? Can we move states, right? That's what we'll have to do, right? If these small island states are disappearing, what are the legal implications? Do we need territory for a state to exist? So there are lots of legal issues involved with additional legal issues involved with small island states and its people. So I think we'll need to look at them differently. I would say forcibly displace people, but the existing framework is not enough, and some have argued that we can amend the Geneva Convention relating to refugees, but I don't see how that's going to happen, both for political reasons and legal reasons, because the Geneva Convention was adopted for within a particular context, and I don't think that can be replicated to cover climate refugees. So many argue that in most instances the movement will be internal. So your state is still responsible, but obviously, if you're in Bangladesh, for example, the system will be overwhelmed if more and more people move inland. And there are concerns if they move into India, for example, due to different religions that are involved. There might be ethnic tensions and things like that. So there's a lot of concern about international security as well as a result of mass movement of people. It's unfortunate that this was not included in the Paris Agreement itself, but the decisions taken at the Paris conference include a reference to a task force to come up with some recommendations with regard to climate refugees. So hopefully something will happen, but it's a huge issue. I think I'll stop there.
Yeah. So
I can
actually
go on.
we are out of time, and we've ended on a somewhat pessimistic note, I think. But it is hard. It's hard not to be pessimistic, really, when you think about the challenges, and even thinking back on what's been accomplished. If the cases that have gotten a lot of press, the Ogoniland case is a case that set some precedent, and then, to the best of my knowledge, nothing really happened on the ground, right? The same violations are still ongoing, 2 decades later or more. And so on and so on, right? So many communities that have brought claims that have either failed or won in the courts, but then didn't get any compliance. And all the challenges that we've raised, the ones that Jason raised, the ones that other people have raised, seem to be so prevalent, right? I mean, it seems like what we need is really, the conditions at the point of production are often so difficult that it's hard to come up with an adequate response. And so it seems like what we need is something completely new, a whole new structure, a whole new framework, something that lets us cross borders, follow supply chains, cross generational divides, look for responsibility wherever we can find it and look for answers wherever we can find them. And that's something that I think we haven't come up with yet, right? So the job, I think, to develop that falls on people like you in this room, the students who are studying now and getting sort of a sense of what the problems are and what the challenges are and what the limitations of our current framework are. So it's up to you. And get to work. Get to work.
That's the responsibility.
So I think we'll just end there. And thank you again, Sumudu, for your presentation.